Welcome to the Justice in Heels podcast. I'm your host, Danielle Hayward, and I'm thrilled to have you join us for season 4 of the podcast. This season will focus on compliance-related topics, and the goal is to simplify compliance for business owners. Let's get started. Welcome to another episode of the Justice in Heels podcast. Today, I am joined by a hopefully regular guest, and I'm going to let you introduce herself again. Gabby, welcome to the podcast. For those listeners who may not know you, maybe just tell us a bit more about yourself.
Thank you very much for having me, Danielle. It's always such a pleasure to be on the podcast. For all the listeners, my name's Gabriela Narotzky. I am an attorney in practice and in corporate as well, having been in practice for 7 years now. And welcome to the second part of our series. Very excited. And if anyone, like I said, in the previous one, wishes to connect with me on LinkedIn to ask any questions, you know where to find me.
Fantastic. So we said that today we'll focus on restraint of trades because I think it's also something that a lot of people encounter in their employment contracts and they don't really know what it is, or if it is actually something that can be actioned. So maybe for the listeners who do not know, what is a restraint of trade and how does it usually look like in an employment contract?
Perfect. So restraints of trade are either incorporated into employment agreements, or if you've already signed an employment agreement and your employer can see that you have obtained either confidential information or trade secrets over a period of time, they generally would require you to sign an addendum to your employment agreement or just a separate document or annexure to record something to the effect of a restraint of trade. So why I think the timing is great for this episode is because I'm sure everyone, well, I don't think everyone, but people in the new year of 2026 are either securing new roles in their current or new companies, getting promotions. And I think it's important that, especially for January, which is the starting month for many, that they are aware of what, their rights are and what these clauses entail. So restraints of trade, to just define them, basically means that you will not, under certain circumstances and conditions, be able to enter into new employment with a new employer or explore or secure new opportunities for yourself in the same or a different space. It's generally for a certain period of time or within a certain kilometer radius of where your erstwhile employer was. So it really limits, it's exactly what it says it is. It limits your right to trade. And it's quite a nuanced concept because, as we know, right to trade and occupation is vested in the Constitution. So it's really a delicate balancing act because ultimately you would be restricted from obtaining new employment. And as we know, in South Africa, employment opportunities are quite scarce to come by. So this is why it is such an important topic to explore as well. And when you do come across a restraint of trade and you aren't sure, it's really important to obtain legal advice on the clause or whatever it may be, in whatever format it comes in, so that you know exactly what you're entitled and not entitled to do. If that explains it better. And like I said, any clarity required, I'm happy to fill anyone in.
Yeah, no, that's definitely clear. So what I've seen is, and I think you see it a lot as well in practice, a lot of people tend to, like employers, go onto the internet and then just get like a random employment contract template, and then they just use it for all of their employees. And maybe there's a trade clause included in there. But so is it something that you see a lot or not really?
It is something that I see a lot. I personally have been on a receiving end of a restraint of trade that was quite onerous. And when I hear people taking agreements from the internet, and just for a quick side laugh, a client told me once that they got a rental agreement from CNA, and I was ready to cry. So that was just a good laugh that I had to share. But so restraints of trade are commonly incorporated into agreements, especially if the company is in quite a specialized or niche industry, and where the employee, at whatever level they may be employed for, or whatever purpose they are hired for, whether it's fixed term or permanent, will be exposed to a lot of the company's trade secrets and confidential information, which I'll go into. Typically, what restraints of trade clauses incorporate is for the employee to not solicit business or disclose certain information, or to go to the company's competitors where they will utilize or not, even if they're in possession of the company's confidential information, they're at risk of still using that to compete with their erstwhile employer. So it's not even it doesn't even necessarily mean that you would have to utilize the confidential information, but where the employer is at risk because you could still be in possession of that confidential information, which is just something important to raise. But we'll still get into it. Lots to share. It's very, like I said, nuanced and quite technical.
So on that note, I want to ask you, is it any type of employee? Because I mean, like most people get into contact with confidential information, but is it like on any level, or is it only at a certain level where restraint of trades are usually utilized?
So I think it would depend on, I just want to say restraints of trade are very much dependent on the facts and circumstances of that particular employee's employment and what the nature of their employment would entail. So it could apply to junior or senior staff, dependent on how that employee would utilize that confidential information to compete with that employer. What was the extent of their exposure? Um, and we also have to keep in mind, very importantly, this is a delicate balance. So if you have obtained qualifications in this space, and if you have a lot of experience in this particular space, no one can take that experience away from you, because the skills that you've acquired are the skills that you've acquired. But it's largely also dependent on what information you've been exposed to. Whether junior, senior, we have to look at, have you seen the company's turnover figures? Are you exposed to, for example, if you work in like a factory that manufactures certain products, what are the secret recipes that you're seeing? Um, are you going to be using those secret recipes and divulging them to your new employer? Because even if you're at a low level job working in a factory, and a laborer, for example, you're still exposed to a lot. You can still take that information to compete with your erstwhile employer or open up your own shop using those recipes. So that's what's interesting. I think it applies to employees on all levels because, like you said as well, at some point, we're exposed to a lot of confidential information in different aspects of the business.
Okay, so let's say somebody now sees that they have a restraint of trade, or they didn't even know they have a restraint of trade, and they now want to leave this specific company and they want to join another company. And then somebody maybe brings this restraint of trade to their attention. What advice would you give them? Is a restraint of trade automatically enforceable? What does case law say about the position?
Perfect. So, restraints of trade are not automatically enforceable. As I said earlier, I've been on the receiving end of a restraint of trade, and I could see it was very onerous. And I thought to myself, good luck to this employer if they think they're going to enforce it in court, because you have to consider a few things. Restraints of trade have to be fair, they have to be reasonable, they have to be lawful. If those are met, then they are enforceable, if they're lawful and if they're reasonable. To test reasonableness, there are four factors that we have to consider. So the first is whether the employer has a proprietary right that is worthy of protection. That's the first step. The second step is if that proprietary interest has jeopardized the employer. Thirdly, if it weighs quantitatively and qualitatively against the employer. And fourthly is if there's any other facet of public interest that requires protection. As we know, employment agreements and agreements in general can never be contra to public policy. And also, we have to keep in mind that employees, just like any other person who is party to an agreement, are bound by their contractual undertakings. So, reasonableness is a test that a court would have to take into account when looking at a restraint of trade. And something that's also very important is that restraints of trade have lifespans. So you have to look at the time period that the employee would be expected to not trade for, and in what circumstances they wouldn't be able to trade, and the kilometer radius. If it's for a period of 3 years, you know that that's excessive and very difficult to uphold. So timeframes in restraints of trade are really crucial, because if you would want to enforce a restraint of trade as an employer, you would have to act fast, because restraints of trade are by their nature urgent. A lot of the time you would bring an urgent interdict to enforce a restraint of trade. So your facts have to be concrete about what proprietary interest you are seeking as the employer to protect, and whether that employee actually has confidential information or if it's information in the public domain. So, for example, if you are an ice cream manufacturer and if recipes similar to yours can be found on the internet, and you have a former employee who's opening up her own shop, do you really have proprietary interests that are worthy of protection if other recipes can be easily accessible? So it really is, like I said, quite a technical exercise to determine. So you would have to see really to what extent is the employee actually harming or jeopardizing your business. And then just to go on to what is confidential information. So confidential information is something that would be applicable within trade and industry. It would be information that is only known to a restricted number of persons, and that information must bear some form of economic value that the employer is seeking to protect. if that also provides you with clarity. So it would need to cause any sort of unlawful interference um, to the current employer from a competitor.
Hmm. So, can you maybe share a few examples of restraint of trade that were overly, like something that couldn't be enforced because it was just too restrictive?
Sure. So, firstly, a court would definitely look at your urgency in bringing that restraint of trade. Did you wait too long? If you did, it will be overturned very quickly by a court. Um, I would say if your restraint is 1 year or longer, I think that is a red flag. If the radius, the kilometer radius, is also just too wide for you to be able to obtain an opportunity elsewhere, very difficult. If it disallows you from seeking employment from other employers, well, not other employers, but from other companies within that industry, not necessarily, a big competitor, but another company in the same space, I would deem that still unreasonable because you would have to look at if that employee has acquired certain skills and expertise that, would enable them to use and apply within another job with that particular skill set. You cannot deprive that employee from trading. So it's really difficult to apply because there's still the constitutional principles that come in. So I would say you would firstly have to look at the length of time, what you are not allowed to do. So meaning, can you still go to other companies? You would really have to see what it's limiting you from doing, looking at the area radius. And the other thing is soliciting business is also another interesting aspect because if clients choose to follow you, you can't prevent them from making that decision. So, for example, as practicing attorneys, or, as if we as lawyers want to open up our own firms or compliance companies and clients from our erstwhile firms or companies or whomever wish to follow us, we can't prevent them from doing that because it's their decision just as much as it is ours.
Exactly. Yeah, no, that makes it very difficult. And I mean, what do you tell the clients? Just like, sorry, can't help you
Yes.
anymore because, you know, it's difficult. I actually had somebody ask me recently. So she works in like the beauty industry, and she had a lot of her beauty therapists actually leaving, and then they take their clients with them because the clients want to actually use that specific therapist, and if she's not
Yes.
working there anymore, then obviously they don't want to use the specific salon anymore. And she
Yes.
really posed a really interesting question, and she asked, but is it my client as the person who owns this beauty salon, or is it the therapist client, which actually also
Yes.
makes it a bit more difficult.
It
But I
does.
think yeah, but I think you actually explained it really well. So my
Thank
follow-up
you.
question on that is then, what can these employers trying to enforce their restraint of trade actually do? Do they claim damages or do they apply for an interdict? What do they do? Because I've seen really interesting, really interesting restraint of trade. Um, for example, I actually had a restraint of trade at the one firm where I worked, where the contract literally stated that the firm can get half of my salary or remuneration at like the next firm that I join if it's within 2 years. And I was like, okay, but what do you do for 2 years then if you can't
No.
work? So yeah,
No.
interesting things.
Mm-mm. That I've never heard of before. I mean, these things can get so interesting. With and employers get very creative with what they want to incorporate. And I must be honest, I know I said earlier, seek legal advice on on these clauses. But in the event that you can't, these clauses will stand to scrutiny in court because they cannot be enforced if they are unreasonable. Reasonableness is the main factor to take into account with these restraints of trade. So you ask me what employers can do to enforce these restraints. So like I said, restraints by their nature are urgent. A lot of the time, employers bring urgent applications on motion, and they have to act fast because of the lifespan of the restraint of trade, whether it's from, even if it's from 6 months to a year, you've got to act quickly because employers believe that if someone is competing with them unlawfully, irreparable harm can be done each day, and therefore you have to act as soon as possible. In the event that a court finds, that the matter isn't urgent and they strike it off the roll for urgency, which, as we know, happens a lot of the time, an employer would then have to quantify their damages and they can bring a damages claim against that former employee, whether it is in arbitration or court proceedings. And it would probably have to be by way of summons to lead evidence, but it's often not. I mean, it can be done practically. I would say a lot of the time, urgent motions are brought. And if employers are unsuccessful, they don't really pursue a damages claim because by that time, too much time has passed. And um, I guess there's also the litigation fatigue aspect. How long are you going to pursue it for? Yeah.
And also, is it worth it? Because I mean, like you spend so much money on litigation. Like, is it really worth the amount that you would lose if this
Exactly.
employee took some of your clients or whatever happened? Like, it's just
Exactly.
commercially, it doesn't really make sense to me. Unless you are
Exactly.
like a massive corporation, then obviously
But
maybe.
is this employee going to be able to pay you back? How are you going to quantify your damages? I think
Hmm.
practically it's a lot more difficult. And that's why, as we know, attorneys don't love summons because they take very long. So they go on motion, especially in the urgent court, because your matter's ventilated, quicker than most proceedings are. So they hope to get some form of relief in those proceedings. And if not, they generally discard the matter. Um, but if this employee is working somewhere else or has set up shop, I mean, what really are your prospects of any recovery from this employee? It's also generally a scare tactic and something to sort of set a standard or a precedent to your other staff to say, like, listen, don't mess with us as a company because, if you do, and if you compete with us, and if you utilize our information in a way that breaches your employment agreement, we're going to come after you.
Hectic. So, so, what mistakes, apart from not getting your employment contracts and restraint of trade clauses from the internet and getting legal advice, what should employers take into account when wanting to incorporate some of these restraint of trades in their employment contracts?
So what I did for my company recently was I actually went through, I've redrafted our employment agreements to make them more fair. And I have basically just commenting on what I've done practically is amended the number of months. It's got to, I would say, I would say restraints of trade should ideally be between 6 to 8 months, so as to not deprive any employee of any opportunities that they may obtain elsewhere, and the kilometer radius, um, shortened it and I've pretty much done the radius so that you don't trade too close to the current employer or the erstwhile employer. I would deem that fair and reasonable. And I think just an emphasis on your confidential information, which understandably needs to be protected, your proprietary interests. So if you as an employee are exposed to the employer's operational structures, trade secrets, turnover figures, business strategies, um, client lists, that kind of a thing, that that can never be disclosed to a third party, and that upon your exit from your employer, you are to furnish all that information and return it so that you don't have any of this and you can go elsewhere and be merry with your new employer. Um, no one can take away the information that's in your mind. I think that's very important to bear as an employee is no one can take that information away from you. No one can take your experience away from you. So I don't think it should be a matter of, you can't go to another law firm. And if you do, we're going to extract half of your salary. That's completely unreasonable. It's just to say, hey, don't pull all of our clients along with you. Don't disclose what our turnover figures are, and it's just ensuring that what you're doing is above board as an employee so as to not compromise our trading activity as the employer or erstwhile employer, if that makes
So
sense.
do you think employees should actually negotiate restraint of trade clauses in their contracts, or should they just leave it? Do you think it's a bit of a red flag for employers if the employee says, "Hey, but I don't really like this clause. Let's negotiate."
Yeah, so it can be either or, Danielle. Sometimes when an employee negotiates at an early stage, employers can view that as a red flag. I mean, as you know, they see that as I don't know, they sometimes see it like you're trying to strong arm them. So I would say, have a gentle conversation so as to also not compromise your position of obtaining new employment. Just to say, hey, can you please explain this clause to me? Why is it for so long? What does it mean? What are the circumstances where, I can't trade because I don't want to also deprive myself of an opportunity, especially if this doesn't work out, because you're now speaking at the very beginning of the employment relationship. And so they can do that. Alternatively, if you can't seek legal advice, or if you feel you're uncomfortable in having that discussion, there's not really harm in leaving it either, because then you would know that it would never stand up in court if it's unreasonable. So I would say you can do either. You really can, because, like I said, if it's unreasonable, it's unlawful, and then it will be severed from the rest of the employment agreement. Oh, that's funny.
Okay, fantastic. So is there anything else that you want to maybe leave our listeners with in regards to restraint of trades?
I would say what is in your head, like I said, can never be taken away from you. And just always keep in mind that you pursued a certain path for a reason. You have the qualifications, skills, and expertise from experience that you can utilize elsewhere. So just bear in mind that that can never be taken away from you. And I would say just be cautious when entering into employment agreements. Read the fine print, read the lines, and in between them. And like I said, if you can't obtain legal advice and your restraint does seem unreasonable, it will never stand up in court, because reasonableness is the biggest test for restraints. So, and if anyone is securing a new role and wants to learn anything further on restraints of trade, please let me know. If there are any attorneys in practice watching this, they're welcome to reach out to me for some good case law on it. I'm in possession of many heads of argument where we've argued on restraints. So please feel free to reach out.
Thank you so much for joining me today. I really hope
Thank
this is not the last, and I'm really
you.
looking forward to our next session.
Me too. Me too. There's more to come. So stay posted.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.